Thanks for having me here today to speak about the past, present, and future medical liability reform in Illinois. Illinois has been traditionally a difficult state for any type of tort reform, and medical liability reform is no different. The lesson I'd like to bring today to you is that with a good organized grassroots effort and capitalizing on the understanding of the political landscape, success is possibly the difficult climate. Whether the court system will go along with it is a different question. Medical liability reforms have been passed in Illinois about every decade or so since but the mid-1970s. However, the major goal of controlling intangible cost in medical litigation, such as pain and suffering awards, has remained elusive even to today. The current story begins about 10 years ago when there was a steady rise in the average indemnity payment paid out. This figure shows the average indemnity payment made by ISBE Mutual Insurance Company since 1980. ISBE Mutual Insurance is the principal medical liability carrier in Illinois then and now, writing nearly 2/3 of the medical liability product in Illinois. While the Consumer Price Index has gone up about 3 times since 1980, the cost of indemnity payments has nearly doubled the CPI. Hence, the cost of medical liability claims has far outstripped normal inflation rates. Coupled with this was a rapid rise in the number of claims filed. In just a few years between 2001 and 2004, there were nearly a 50% increase in the number of claims filed. By 2004, medical liability rates for many physicians had doubled, and in some specialties had tripled in a short period of time. This was a significant overhead shock to many physician practices who were unable to pass this cost along to healthcare insurance companies. Also at this time, there was a recognition by many tort reform-minded groups that certain counties of the country were noted to have significantly higher litigation rates and unfriendly tort outcomes. These areas were labeled judicial hellholes. Illinois has the dubious honor of having 2 of the worst judicial hellholes: Cook County, which in Chicago is located, and probably the granddaddy of all, Madison County, a small county of about 265,000 citizens across the Mississippi River from St. Louis, Missouri. The effects of the malpractice crisis cost was especially felt in the lower half of the state. For a period of time, there were no neurosurgeons in the lower half of the state. Obstetricians in some hospitals quit delivering babies, and people had to travel miles to get care. Madison County was especially struck with the loss of physicians. Patients began to notice the lack of medical care, as were many civic and business leaders. It's hard to encourage businesses to move to your area if the healthcare system is failing. In 2004, the Illinois Supreme Court justice in the Madison County area retired, leaving an open seat with the election to be decided by the voters of that area. Many businesses and civic leaders, as well as local physicians, county medical societies, the Illinois State Medical Society, ISBE Mutual Insurance, and the Illinois Civil Justice League recognized the opportunity to elect a tort-friendly Supreme Court justice in this judicial hellhole. In what was the most expensive state Supreme Court race on record, a total of $9.3 million was spent by both sides. Lloyd Carmeier, a Republican, our candidate, was elected. His opponent was not only not elected to the Supreme Court, but also failed to retain his appellate court position. The political implication to the Democratic leadership, which controlled the Illinois Senate and House, as well as the governor's mansion, was significant in spite of their stated opposition to any medical liability reform in Illinois. They recognized there was a good possibility that many of the Democratic representatives from the southern Illinois, and to some extent other parts of the state, could lose their seats in the following November race, tipping the power of the Republicans. With a lot of work, a medical liability reform was passed by the legislature in May of 2005. It became law when it was signed by then Governor Blagojevich in August of 2005. Our medical liability reform is very comprehensive, involved many groups, and believe it or not, included input from the trial attorneys. It had support from both political parties in all areas of the state. It included a $500,000 limit on non-economic damages for physicians, a $1 million cap for non-economic damage for hospitals. I'm going to talk a little bit later why we view caps as being so important in any type of medical liability reform. It also had strong rules regarding who could serve as expert witnesses. There were some court procedural improvements and some other minor provisions. Contrary to what some opponents of this bill were saying, there was no limit on any economic damages, such as lost wages or ongoing medical care. When we drafted the 2005 bill, we took into account the court had with our earlier medical liability reform bills. In fact, when they overturned our 1995 medical malpractice reform bill, the Supreme Court was very specific on the reasons for their objections. We took these objections as a blueprint we used to pass our 2005 bill. While we were optimistic, we anticipated the possibility that one or more of the parts of the bill might be struck down by the Supreme Court. Because the bill contained compromises put forth by the trial lawyers that were not physician-friendly, we wanted to make sure that the good provisions couldn't be removed, leaving us only with the bad ones. As a result, we included an inseparability clause, meaning that if one part of the bill was struck down, the entire law was invalid, and ultimately that's what happened. I mentioned earlier, why do we view caps on non-economic damages or pain and suffering awards to be so important? Insurance companies need predictability to assign rates for any product you buy, whether it's auto, home, or life insurance, and medical liability carriers are no different. If there's an injury that needs to be paid, the medical liability carrier can predict and put aside money to pay for ongoing medical care and lost wages. That part is predictable to the insurance company. What they can't predict is the pain and suffering component in a liability claim, which can be the most costly portion of the claim. Will it be nothing, $1 million, $10 million? No one knows what the cost is going to be. Thus, the insurance company has to charge a lot more and keep more money in reserve to cover this unpredictable loss. After the passage of our reform bill, several positive effects were noted. ISBE Mutual's figures show that since the height of the lawsuit crisis in 2005, right before our bill was passed, reported claims against their policyholders have gone down by more than a third. We think this is the direct result of our liability reform law and the precedent received. The malpractice lawyers, we think, decided that many of the cases they normally would have brought, hoping to pursue a jackpot judgment, would no longer be profitable. This meant less cost to defend cases, fewer awards made to malpractice, made to plaintiffs, and fewer premium dollars that were needed. For example, for ISBE Mutual policyholders, the average premium either held steady or has reduced over the past 5 years, and ISBE Mutual has distributed over $54 million in dividends to its physician insurers. A decrease in the number of malpractice cases wasn't the only benefit of our reforms. Before reforms were passed, there were 5 or 6 insurance carriers writing liability policies in Illinois. This is because few companies could manage the risk in the hostile Illinois climate. Simply, the risk of writing these policies was high, and most companies couldn't take the risk in a poor market. Since 2005, the number of malpractice insurers has almost doubled. There are now 9 or 10. This is because of substantial improvement in the market conditions, making the risk of losses more predictable. An added benefit is increased competition, which drives down prices for physicians. An interesting finding is that one of these new startup insurance companies was set up by some class action and malpractice attorneys from, believe it or not, Madison County. You won't find their names on the company's website, but they are listed on the official incorporation papers filed with the Illinois Department of Insurance. A third benefit was that physicians, especially those in high-risk specialties, began moving back to notoriously high hospital jurisdictions like Madison County. We also had to battle a number of misconceptions offered by the trial lawyers. First of all, trial lawyers claimed that doctors never were leaving Illinois and there never was a crisis in access of care for patients. Matter of fact, they never say there never was a crisis. What they use is licensing data to prove their claims, saying that the number of doctors licensed in Illinois has remained steady for years. Counting the number of licenses does not give an accurate picture of the medical care in this state. First of all, in our state, medical licenses are good for 3 years, and a lot can happen in that time. It also doesn't reflect that many licenses are maintained, that many physicians maintain licenses but do not practice in Illinois. Some retired doctors, and many in my county, actually keep their licenses so they can treat patients occasionally or volunteer, but it's not accurate to represent them as physicians engaged in the patient care on a full-time basis. Some doctors maintain licenses in multiple states, and Illinois may not be where they spend most of their time. We also have many physicians who serve as administrators and don't see patients at all. And finally, the licensing data does not show those who limit their services. The State Medical Society recently published a study which showed that nearly 2/3 of Illinois physicians limit the type of care they provide due to liability concerns. However, it's odd that the attorneys are quick to propose solutions to a problem they think never existed. One of the solutions they offer is that more regulation will bring more insurance carriers. More insurance regulation will do nothing to address the amount of risk the insurers face. The real problem, as I stated earlier, is the uncertainty in the amount of pain and suffering damages awarded. As long as there's no limit on the damages, liability policies will continue to be expensive. and no amount of regulation is going to change that. Another solution is if we just got rid of bad doctors, there wouldn't be a problem. Obstetricians and neurosurgeons are sued frequently because of complicated cases with bad outcomes in spite of the best care given. Could all these doctors be bad? Did they all receive inferior training? Of course not. As an anesthesiologist, I can move into Missouri or Iowa or East Indiana and save almost 1/3 of my malpractice insurance. How did moving across the Mississippi River or traveling east to Indiana make me a better doctor? So what did the Supreme Court do? About 2 years ago, it heard oral arguments concerning this case, but it took them nearly 16 months to render a decision. On February 4th of this year, the Illinois Supreme Court handed down its ruling in the case of LeBron versus Gottlieb Memorial Hospital. This was the medical malpractice lawsuit that was used by the trial lawyers to challenge our reform law. Voting 4-2, the Illinois Supreme Court agreed that the limits on non-economic damages put in place by the legislature violated the separation of powers clause of the Illinois Constitution. The court's premise was that only the judicial branch could reduce awards. Now, because of the inseverability clause I spoke about earlier, throwing out one portion of the bill forced the courts to throw out the whole law, which is what they did. Soon after this ruling was handed down, Isby Mutual joined Gottlieb Memorial Hospital for a rehearing of the case based on the legal precedent established 50 years ago. In this case, the Supreme Court had upheld the Illinois legislature's right to limit non-economic damages in divorce cases. Unfortunately, our petition for a rehearing was denied in May. In summary, we're back to where we were before 2005. As fate would have it, 3 of the Supreme Court justices who voted against our medical malpractice bill were finishing their 10-year terms of office. While it was our goal to remove all 3 justices, we only had limited resources for this task. Our target was Justice Thomas Kilbride of the 3rd Supreme Court District in the central part of the state. Again, we partnered with other civic and business groups who were concerned with Justice Kilbride's judicial record. In these retention races, there are no opponents running against the sitting judge. All they need to do is keep their jobs and garner 60% of the vote. This was a very difficult task. We were outspent by our opponents at least 3-1. This election also set another record, the most money spent on a judicial retention race in United States history. The last count was $3.1 million, and the final tally hasn't been published yet. We were nearly successful. Justice Kilbride was retained, but received only 66% of the vote when typically judges in Illinois are retained with rates of 80% or greater. While we were disappointed, a significant amount of money was diverted by our opponents to this campaign that was not available for other elective races. And I think a good lesson is that all judges should learn that, whether they like it or not, that they're accountable to the citizens. Now with the judicial retention elections over, what are our possibilities for future legislative solutions? We're looking at reinstituting certain components of the 2005 law that was not struck down by the Supreme Court. The whole law was struck down by the inseverability clause, but the justices only commented on the caps portion. Thus, the rest of the provisions are still on the table. We would like to see that expert witnesses in medical malpractice cases be board certified in the same specialty as the defendant. Further, that they devote the majority of their time to practicing medicine. No more retired physicians from Florida serving as malpractice experts. This will help ensure that those who testify as expert witnesses really live up to that designation. Another idea is allowing awards to be paid in annuity. The plaintiff would receive the total sum over a period of time rather than one large lump sum. Lastly, we'd like to see the transparency in the affidavit of merit process. Currently, the plaintiff must present an affidavit certifying that their lawsuit is not frivolous, but the person signing the affidavit is not even required to disclose their name or have expertise as it relates to the lawsuit. Some of these other options have been discussed by Mark earlier, and I'm not going to spend a lot of time talking with him, though I'd like to comment on the idea of changing the Illinois Constitution. This may seem like a great way to solve the problem for once and for all. It's worked well in Texas and California, both which have significantly lower medical malpractice rates than Illinois. However, the results of last week's election in Illinois still left the Democrats in control of the governorship as well as the legislative houses. These are the same people who opposed our previous reform bills and are closely tied to the trial lawyers. It's these same officials who would oversee the process of changing the Illinois Constitution. We have a very real risk of ending up with a change in the Illinois Constitution essentially written by trial lawyers and for trial lawyers. At this time, we feel a constitutional convention or an amendment would pose a great risk of harm, and we feel it would be more productive and less risky to pursue conventional legislative solutions that I've outlined earlier. Thank you very much.